Hello, this is Matt on the Moon Lambo channel. What can I say? So many legal developments in the SEC versus Ripple lawsuit, in particular today, certainly in recent days as well, but specifically today. In this latest Moon Lambo hot jam, I'm going to share with you what Ripple's lawyers are saying. They are pushing back strongly against the SEC, asserting that the SEC is seeking to operate a veil of secrecy, and they said that also there's like what they're pushing for is a quote unprecedented level of secrecy end quote, and they want to shield everything that will be stated by all of their experts moving forward, even the ones whose public information is already available. And Ripple's attorney just ripped this to shreds. So the what was filed today was signed by Andrew Seresny, who formerly worked at the SEC, mind you. So this is one of Ripple's lawyers, and he just tears this concept to shreds. So it's technically 4 pages, but the last page is only signatures. So I highlighted the parts that I found to be most interesting, and I'm going to share them with you along with some commentary. But before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. First and foremost, a shout out to John Deaton's Crypto Law Organization for sharing this most recent legal filing, and also shout out to James K. Filan, member of the XRP community, and he's an attorney, for sharing this as well. Now, upon reading this, attorney Jeremy Hogan had the following to say. He wrote, Attorney Seresny, and again, that's, as I cited just a minute ago, Attorney Seresny, Andrew Seresny, is the one that wrote this. It's his signature line, and then the other law firms, latched upon, but it seems as though he's the one that actually authored this. So here's what Attorney Hogan said. Attorney Seresny is a Yale Law graduate, clerked for some big-name judges, represented the biggest financial institutions in the world, and was the director of enforcement for 4 years at the SEC. He does a good job with this brief, but he's no John Deaton. And he's got a little laugh emoji. Now, I think the reason he's saying that is, you may be aware at this point, Attorney John Deaton filed a document to Judge Torres today, and I already covered it in my very last video, which I think was like 41 minutes long. It's one of my longest videos ever made, thoroughly covering exactly what happened. But Attorney John Deaton, excellent write-up, defending himself, and just, you know what, it's a bunch of stuff. If you haven't seen it, I encourage you to check it out, but I'm just going to move on from there. So let's get into the actual document, and this is addressed to Judge Torres. Defendants Ripple Labs, Inc., Bradley Garlinghouse, and Christian A. Larson, together defendants, right to oppose the SEC's request to impose an unprecedented level of secrecy on these proceedings by sealing all identifying information in the Daubert motions regarding its 5 proffered expert witnesses. The SEC's application should be denied subject to the very limited exceptions set forth below. So I'll pause to note, what the SEC is doing here is they're trying to prevent information from reaching you listening to this and me speaking these words. They don't want us to see this because, as it turns out, it's not so fun to have masses of the public against you, and I don't think the SEC is enjoying that very much, but the facts and circumstances aren't on their side, and they are harming the everyday crypto holder, specifically XRP holders today. And when they're saying here, as they noted in what I just read, that there are Daubert motions regarding the SEC's 5 expert witnesses, the Daubert challenges, these motions, are motions challenging a couple things. It can be the actual expertise of the so if you have somebody who is you're claiming is an expert, but they don't actually know anything about that, then you can file a Daubert motion. You can challenge and say this isn't a for real expert. They're just calling this person an expert and trying to get them chucked out, right? You can also say, okay, well, this person may be an expert in the field, but they've got flawed methodology. So there you go, another Daubert motion. So that's what they're talking about there, just so everybody knows, make sure we're all on the same page. Anyway, Attorney Seresny continues. The SEC's proposed redactions are the opposite of narrowly tailored. They would completely obscure the identity, educational background, employment history, publications, and professional affiliations of all of the SEC's proffered experts from public view, despite such information being central to the resolution of the parties' Daubert motions, and despite some of that information already being public. The SEC cites no case, and defendants are aware of none, where a court sealed the identity and qualifications of an expert witness in the context of deciding a Daubert motion. This court should decline the invitation to become the first. Whew, I love that. The first time I read that, I was like, yeah, the court should decline the invitation to become the first. So no, there is no legal precedent for this. The SEC is insisting this veil of secrecy, and there is no precedent for it. They just want the secrecy because reasons. Now, again, like I said a minute ago, we know the real reason, right? My speculation, certainly, is that they can't take the heat from the public, you know? And of course, I'm completely against anybody doing anything illegal. You should not threaten people and so that. But if they're just like, we strongly believe very differently than what the SEC is asserting, and they find it to be so problematic to the point where they just want to pretend we don't exist and don't want us to be fed information. They want the transparency shut down. Well, that's on them. You know, they're the ones that brought this damn case. What do they think? That we're just welcome them with open arms? Oh, you're destroying our finances. Yes, please. No, of course not. Attorney Serezny continues. The SEC claims this extreme step of sealing its experts' identities is needed as a prophylactic measure, I love that line, to protect their safety, prophylactic measure, and relies entirely on the court's prior ruling sealing certain information about SEC experts 1 and 5 in connection with a motion by Amici to access SEC expert 1's report. So I'll just pause to note, Amici, as referenced there, that's the 68,000 plus XRP holders as represented by attorney John Deaton. And when they reference experts 1 and 5, they're referencing two of the total. I think there's a total of 5 expert witnesses the SEC has, and they're calling them numbers 1 and 5 instead of their names. That's all that is right now. Although we do know 2 of their names. That's already been made public. Anyway, attorney Serezny continues. But this motion to seal is distinguishable from the prior motion, given the importance of the Daubert determinations in this matter. And the SEC provides no basis, other than speculation, for finding that disclosure of the experts' identities would trigger consequences that should override the substantial presumption of public access to these documents. Oh, I'll just pause to note, too, you're going to find out in this video, one of the things, I'd never seen this before, but you're going to find out one of the things that was done that's allegedly inappropriate that has resulted in the SEC calling for this complete veil of secrecy. Wait till you hear what it is. I'll point it out when we get to it. It is absurd what they're saying is actually some sort of threat. It is, you tell me what you think. I don't think it is even close. I mean, you could say it's inappropriate, and I would never encourage someone to do what they did, but a threat? When we get there, you'll know. But I'll make sure to cite that that's what I was talking about. But just give him. Let me go through this in order here. Anyway, attorney Serezny continues, and he says, indeed, the available evidence suggests that disclosure of the experts' identities would not have the consequences the SEC suggests. For example, the SEC fails to acknowledge that the identity, reports, and deposition transcript of SEC Expert 5 have all been publicly available since at least March 2022. The SEC has not presented any evidence of conduct toward Expert 5 since that public filing in March, 4 months ago. That now justifies sealing swaths of the defendant's Daubert motion in Expert 5's already public reports and testimony. Now let me scroll down a little bit further here because I'm going to skip over the legal standards on your screen if you want to read it. I don't think it's necessary to get the key factors across. They're talking about precedent and such. I don't think it's necessary to get to like the nuts and bolts of this. If you want to know how the sausage is made, you can pause and learn even more. But here we go. So we're going to go down to Part B here, discussion. Check this out. For all 5 of its proffered experts, the SEC speculates that the potential for threats or future online harassment justifies sealing their identities in the Daubert motions as a prophylactic measure. I love that again. The SEC's expressed concerns are not supported by the kind of specific, compelling facts necessary to justify such an extraordinary sealing request. And then they go on to explain why, so check this out. From Attorney Serezny. SEC Experts 2, 3, and 4. The SEC has made no showing at all relating to these experts to justify its extensive proposed redaction. So let's pause. Those 3, I don't know who those are. As far as I know, they've not been made public. But basically, it's the SEC saying everything about them, period, and everything they have to say should not be made public because reasons. That's what the SEC is arguing right now. It doesn't make any damn sense, which is why Attorney SECRECY is pushing back so hard against this crap. Then he talks about expert number 5. Now, we do know the identity of expert number 5, so check this out. This expert's identity is already publicly known and has been for several months. His reports and deposition transcript have been filed on the public docket since March, and his deposition transcript was publicly filed by the SEC itself. So pause and think about this. The SEC's crying, no, we can't have this information out there. They put it out there. You dumbasses. Jesus. Well, it's because they hadn't come up with this completely convoluted idea. It's so disingenuous to argue that there's this danger against all of their expert witnesses. It's so contrived. It's such a contrived argument. That's what I think, anyway. Anyway, Attorney SECRECY then continues. The SEC has made no showing justifying. Wait, did I miss that? Yeah, there we go. The SEC has made no showing justifying sealing information that is already public. At most, they have identified a single non-threatening text message from 3 months ago that shows only that someone reached out to the expert via text message to say that his report was very flawed. That sort of straightforward criticism does not suggest any danger to the expert and cannot justify the sealing the expert's identity. So look, I believe that the expert that they're talking about here is Dr. Albert Metz, and I'm guessing that through context. He's the expert that was paid $600 an hour or so by the SEC to write a 100-plus page report showing ultimately that, and the report's public, I've showed it on my YouTube channel, but he argues in part that if not for Ripple, the company, XRP would never have gone above 2 cents and crap along those lines. It's just bogus stuff. So XRP would have been the only cryptocurrency on the planet to not go on the parabolic rally of 2017. Would have been the only one. He actually argues this BS. It's complete nonsense. So look, again, do not reach out to anybody participating in this case. I don't care if it's an expert witness or attorney or a judge. Do not reach out. You're not going to help anyone. It's inappropriate. Now, somebody did here, and so I don't support this, to be clear. Do not do this. But the text message said to this expert, and again, don't do this, but the message just said that the report was very flawed. Where's the threat? So yes, it's inappropriate to go to that. Like, you don't do it. I promise you're not helping. Look, this is being reported on the SEC. And what if the judge actually, I don't think the judge will side, but what if the judge actually sided because of this? You're harming the case. And you're harming the level of transparency of the case. Just don't do this. It's not acceptable. So not defending that. In fact, I don't like that it's occurred. I'm very upset by it. Because it damages the case, if anything, for our side. But still, you look at that and it's just like, okay, it's not a threat though. You're just saying, I don't like your report. My gosh, what sensitive individuals. Then there's SEC Expert 1. We also know who SEC Expert 1 is. This is publicly available information. I'm not revealing anything that's secret. I would not do that. SEC Expert 1's identity and high-level substance of his proffered opinion are already publicly known. And indeed, the name of SEC Expert 1 appears in the docket entries for 2 of the SEC's own filings, in this case to this day. At this point, the SEC's redactions would be effectively futile. The public will easily be able to identify SEC Expert 1's identity and his reports and deposition transcripts based on what is already public on the docket and known about his opinions. And so again, I'm not breaking any sort of secret here. Through context, my speculation is that they're talking about one Patrick Doody, who has a very hilarious last name. That's great. We can all agree on that, right? And so he's the one that claims to know why people purchased XRP, yet he didn't speak with any XRP holders about why they purchased XRP, but he's the expert that knows. And he's going to say it's all speculation and crap. Bunch of garbage. And so again, be good people. And I know I don't need to say that to like 99.999% of you, but you get a huge group like the XRP community that's made up of like literally millions of people, have a sufficiently large group with a shared interest of any kind, and you're going to have some people that are a little bit, on the fringe side, some a little bit more kooky. You're going to get, let's just say it like this, you're going to get a little taste of all God's animals, you know what I'm saying? So, I'm not speaking to the vast majority of you, but if you are one of them out there, please rethink, and just don't reach out to anybody participating here. And there's just a few more spots that I highlighted. Right about here. SECRECY wrote, Notably, in rejecting the SEC's proposed redactions of the expert's report, the court disagreed that the public should be prevented from accessing information based on concerns that it will provoke strong feelings. And that's a quote, by the way. So, and I had already covered that on the channel previously, so I have a feeling that the response to this, it's going to be favorable, but I wanted to highlight that as well, just so you're aware. And then there's also this portion right here, which reads as follows. That an expert's opinion or qualifications to render an opinion may be subject to criticism in the public square is obviously not a basis for sealing, even if the expert in question finds such criticism to be uncomfortable. The SEC's experts are paid professionals whose opinions the SEC is leveraging in a public enforcement action against defendants with wide-reaching potential consequences for them and their industry. Well, ain't that the truth? Then there's, I also want to read this one right here. So, there we go. The only redactions the SEC seeks that are appropriate are those that actually protect sensitive, non-public, personal or financial information. Well, there you go. I can get behind that. Ripple's behind that. Fine, redact that stuff. If there's something super sensitive like that, yeah, I think we can all, as reasonable people, get behind that. But to just say, no, everything is secret because reasons, oh, hell no, son, get your bitch ass out of here, I am not in line with that. And then this is the last part that I highlighted because the next page is just the subject line. Check out this stuff. Andrew Seresny wrote, none of the other redactions the SEC seeks should be allowed. Having chosen to bring this case, the SEC cannot litigate it behind a veil of secrecy. Bam. Good stuff here. I love how this guy writes. It's been a good day of legal stuff. A lot to cover, but man, I'm having a good time with it. I'm so optimistic for this case. It's like, we'll see what happens here, but I don't see how the judge could fall for this. Good things in time. I'll go ahead and wrap up here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.